House Bill 543, an act related to public safety, is currently making its way through the Florida state legislature. If it passes, Governor DeSantis has already vowed that he'll sign the bill. It's looking good. There's two separate versions of this bill. The first version was filed at the end of January. It's 63 pages long. The second version was filed at the end of February, and it about doubles the bill in length. The first version of the bill is almost solely focused on the unlicensed concealed carry of firearms being lawful in Florida. The second version of the bill adds on an entire new public safety component with regards to school systems. It encourages and mandates the sheriff's office to develop programs and to employ people that can be armed within the school. It also provides the schools with options in order to reach out to other sheriffs of surrounding counties and I believe private sector in order to fulfill these staffing requirements to make sure the schools are safe. In preparing for this video, I downloaded the first version of the bill, so my page references are going to be slightly off. The second version of the bill doesn't modify the substance of the things that we're going to be discussing. We're going to jump right into it. Let's turn to page number 9, where you'll see the definition of handgun has been added to the definitions section under 790.001. So now subsection 10 of that will be the definition of handgun. But wasn't the definition of handgun already in the statute? Doesn't that seem like something that should have already been there? Well, it was. That exact same definition of handgun was previously located, you can see on page number 41, it was located under the Florida statutes regarding hollow point bullets and armor piercing rounds. They removed it from that narrow subsection and applied the handgun definition to the overall instructions under 790. If we turn to page 12, we get to the core substantive changes of law within this bill. Modifying 790.01, which is currently the unlicensed carry of concealed weapons and concealed firearms, and now modifies that to being carrying of concealed weapons or concealed firearms. Here's the modification of the law. A person is authorized to carry a concealed weapon or concealed firearm as that term is defined in 790.06 subsection 1 if he or she is either licensed under 790.06. So you have your concealed carry permit. So that's one option. Or B, if you're not licensed under the concealed carry permit laws, but otherwise satisfies the criteria for receiving and maintaining such a license under statute 790.06 subsection 2, A through F, and I through N, 3, and subsection 10. That's a lot. So what does that mean? 790.06 subsection 2, A through F. So is a resident of the United States. Got it. Is over the age of 21. Got it. Does not suffer from a physical infirmity which prevents the safe handling of a weapon or firearm. Got it. Is not ineligible to possess a firearm pursuant to having been convicted of a felony. Got it. Has not been found guilty of a crime under the provisions of Chapter 893, that's the drug laws, or similar laws of any other state relating to controlled substances within a 3-year period immediately preceding the date in which the application is submitted. So no possession of marijuana charges, or has not been committed for the abuse of controlled substance under Chapter 397 or former provisions of Chapter 396 or similar laws of any other state. So that's the Marchman Act. F, does not chronically and habitually use alcoholic beverages or other substances to the extent that his or her normal faculties are impaired. It shall be presumed that the applicant chronically or habitually uses alcoholic beverages or other substances to the extent that his or her normal faculties are impaired if the applicant has been convicted under 790.151, that's using a gun under the influence, or has been deemed habitual offender under 856.011, that's like drunk and disorderly, or has 2 or more convictions for 316.193 within the 3-year period immediately preceding the date on which the application is submitted. So this first sentence is does not chronically and habitually use alcoholic beverages. That's the law. They give the state of Florida a method to prove this with a presumption. This could be proven through other means, but if any of these circumstances exist, then that will be presumed to be the case, that you would violate this. All right, G. So this one was removed. desires a legal means to carry a concealed weapon or firearm for lawful self-defense. So that's no longer required. H was also removed. H demonstrates competence with a firearm by any one of the following. And it lists out all the different classes you could take in order to be satisfied for a concealed carry permit. None of that's required any longer to carry without a concealed carry permit. So G and H are taken out of the law. I has not been adjudicated incapacitated under 744.331, and J has not been committed to a mental institution under Chapter 394. Both of these would require that you be declared competent to own a firearm by the doctor, and you can have that reinstated. K has not had adjudication of guilt withheld or an imposition of a sentence suspended on any felony unless 3 years have elapsed since probation or any other conditions set by the court have been fulfilled or expungement has occurred. This one could be a problem. I help people get their CCW permits when they've been denied. Several of my clients have been denied because they had a felony dating back to the 90s that they paid everything off, they had everything done, and then like a late fee was assessed afterwards, and there was $16 or something stupid owed on the amount. But since that balance wasn't paid until 2022, they can't get their concealed carry permit because that case didn't fully close out. So if you're going to be carrying under this law, you better verify that all your past baggage is 100% closed. I would have certified dispositions, and I would have zero base balance on everything. L has not had adjudication of guilt withheld or imposition of sentence suspended on any misdemeanor crime of domestic violence unless 3 years have elapsed since probation or any other conditions set by the court have been fulfilled. Okay, so there we go, 3 years, misdemeanor DV. M has not been issued an injunction that is currently in force, in effect, and that restrains the applicant from committing acts of domestic violence or acts of repeat violence. N is not prohibited from purchasing or possessing a firearm by any other provision of Florida or federal law. This one causes me some confusion because medical marijuana is illegal federally, but legal in Florida. So can they use this provision of law and then tell someone, hey, you've got medical marijuana, therefore you are violating federal law, so therefore you are violating the provisions of this statute. You are not authorized to carry a concealed firearm unlicensed. I don't think they're doing that, but I think that's available as an option. Subsection 3 of the statute requires a 3-year waiting period if you have an adjudication of guilt or a withhold of adjudication on any misdemeanor crime of violence that's not domestic and obviously not a felony. So you can be adjudicated of battery and still get your concealed carry permit 3 years later, once everything's 3 years after everything's closed out. Subsection 10 just says that if any of these things occur while you currently have a concealed carry permit, then the Department of Agriculture revokes that permit, and until you've satisfied the conditions, your permit is suspended or revoked. So let's get back to the law. If you recall, prior to that little sidetrack, we were reading through that a person can carry a firearm even if they're not licensed, as long as they meet the criteria of 790.06 to A through F, I through N, 3, and 10. We've now covered all those. So let's keep going on. Except as otherwise provided in subsection 4, a person who does not meet the criteria in subsection 1 and who carries a concealed weapon or electric weapon on or about his person commits a misdemeanor. So if you don't meet the criteria and you carry a weapon, then you're committing a misdemeanor. Keep reading. If you carry a firearm, you're committing a felony. There's 2 exceptions to this law. A person does not violate this section if they're lawfully in possession of a weapon or firearm as they're fleeing during a mandatory evacuation order issued during a state of emergency declared by the governor. So that's 1. There's additional requirements with that, but this is not a new area of law. The second exception is for chemical self-defense spray. All this underlined text indicates new law. 790.013, carrying of a concealed weapon or concealed firearms without a license. A person who carries a concealed weapon or concealed firearms without a license as authorized under this section must carry valid identification at all times while he or she is in actual possession of a concealed weapon or a concealed firearm and must display such identification upon demand by law enforcement. Violation of this section is a non-criminal violation punishable by a fine of $25. So if you're carrying a gun under this section, you've got to carry a form of valid identification on you and present it to law enforcement. Let's go on to subsection 2. This is a big one. Is subject to 790.06 subsection 12 in the same manner as a person who's licensed to carry a concealed weapon or concealed firearm. Remember 796.06 subsection 12, that's the list of all the places that you can't go inside with your concealed carry permit. Any place of nuisance, any police sheriff's office. The bottom of page number 14, the law discussing Florida non-residents and reciprocity, is where I think this bill is really a hallmark for the Second Amendment. The default provision here is that even if you're not a resident of Florida, you are still 100% entitled to carry a firearm within Florida as long as you meet those baseline requirements. You have to be over the age of 21, you have to be a resident of the United States, and otherwise meet the requirements that we just previously discussed. And if you're a service member, that 21-year-old age requirement is waived. Turn to page number 18 of the law, we'll see a modification that if you're stopped by police and you have a concealed carry permit, you're no longer required to provide that concealed carry permit. You only have to provide valid identification. If we turn to page 27, we'll see that the 3-day waiting period law has been changed, but the changes they made are just procedural. If you have a concealed carry permit, there is no waiting period. If you don't have a concealed carry permit, you're still going to have to wait the 3 days. So if you turn to page 30 and 31 of the law, we'll see that the punishments for carrying a firearm or carrying a weapon to a school-sponsored event has been modified downward if you're a lawful concealed carry holder or a otherwise authorized to carry a weapon. If you're not authorized to carry a weapon, penalty remains a third-degree felony. A person who's authorized to carry concealed weapons or concealed firearms under 790.01 and who willfully and knowingly violates paragraph B or subparagraph C1 commits a misdemeanor of the second degree, and B and C1 is carrying a firearm or weapon at the school-sponsored event, that type of thing. If we turn to page 38, we'll get to possession in a private conveyance. They've cleaned up the language of this. The substantive rights remain the same. So if you're familiar with how the law was previously, we'll do a recap on it, but it should be all the same for you. Notwithstanding 790.01, a person 18 years of age or older who is in lawful possession of a handgun or other weapon may possess such a handgun or weapon within the interior of a private conveyance if the handgun or weapon is securely encased or otherwise not readily accessible for immediate use. Remember, I never go that way. It's always securely encased. A person who possesses a handgun or other weapon as authorized under this paragraph may not carry the handgun or weapon on his or her person. So 18 years of age, securely encased, and it cannot be on your person. This subsection does not prohibit a person from carrying a legal firearm other than a handgun anywhere in a private conveyance when such firearm is being carried for lawful use. So if you got a long gun, you can carry it anywhere, AR-15, shotgun, anything but a handgun. Notice there's been no mention of concealment here. No concealed carry mention at all. It doesn't matter whether the firearm is visible from the outside or inside. It only matters that it's securely encased. B, this subsection does not prohibit a person from carrying a concealed weapon or concealed firearm on his or her person while in a private conveyance if he or she is authorized to carry a concealed firearm under the provisions of 790.01. If you're authorized to carry a firearm without a license under everything we previously discussed, you can still carry a firearm on your person. But if you're not qualified, for instance, maybe you're 19 years old, you can only carry under the provisions in your vehicle under this statute. If you've looked through this law, you might be wondering what all this stuff on page 42 is about. You'll see it says offense severity ranking chart level 5. And if we turn over a few pages to page 44, we'll see at the very bottom, it says 790.03, unlawful carrying of a concealed firearm. This entire table was placed into this law for this little section to be modified. It's more procedural than anything else. In the big scope of things, when someone's convicted of a felony, They use a score sheet to determine how much jail they're going to get. This offense is a level 5 offense, meaning it scores 28 points by itself. There's a mathematical formula that can be computed, and depending on how many points you get, depends on the length of the sentence that you're issued. Thanks for taking the time to educate yourself on Florida gun law.